I'm Duke Fagan. Today we're going to talk about how you can be charged with a crime in Florida. Despite what many people tell you, including the police cannot charge you with a crime in Florida. The police can arrest you on probable cause for committing a crime, but they do not have the power to charge you formally with a crime. By charge you with a crime, I mean to make you appear in court and answer to criminal charges. The police can arrest you on probable cause for committing a crime. Probable cause means that a law enforcement officer believes that under the circumstances at the time, it's more likely than not that you committed a crime. That justifies your arrest. It does not charge you with a crime. No matter what the police may tell you, they cannot charge you or uncharge you with a crime. Only a state attorney or a grand jury can charge a citizen with a crime in Florida. When you're arrested on probable cause, you're taken to jail. A determination about your bond will be made, and we'll talk about that in another video. But I want to go on and talk to you now about whether or not you're charged with a crime. Once you're taken to jail, once your bond is determined, the file will go to the state attorney's office. The state attorney will look at the file and make a charging decision. Because once again, you aren't charged with a crime until the state attorney charges you with a crime. The way a state attorney charges you with a crime in Florida is by filing a document called an information. An information is the legal name given to a criminal complaint in Florida. The other way a state attorney can charge you with a crime is by taking your case to a grand jury, giving them evidence, and allowing the grand jury to vote as to whether or not you should be charged with a crime. Almost all cases in Florida are charged by the decision of the state attorney alone to file or not file an information. When the state attorney gets your file after arrest, the state attorney will look at the narrative in the file and any other evidence they may have. After your bond has been determined, the file will go to the state attorney's office. The state attorney can make one of four decisions. The state attorney can decide to charge you with the same charge that the police arrested you on. Or the state attorney can look at the file and say, I don't think we can prove that, but I think we can prove a lesser charge. So the state attorney can decide to charge you with something less than what the police arrested you for. The state attorney can look at the file and say to himself, I think we can prove more. So the state attorney can charge you with a higher level offense than the one the police arrested you for. And the last option the state attorney has is to decide not to charge you with a crime at all. That is, drop the case. If you're arrested, it's critical that you call a criminal defense attorney as soon as possible. Your lawyer will need as much time as he or she can get to gather evidence and to try and persuade the state attorney to charge you with a lesser crime or not to charge you at all. Thank you. We'll talk again.